Professor Arthur Burns was a prominent professor in international relations until he became sick in 1981. He went on a period of extended sick leave. Now, obviously, this sort of thing happens from time to time, and I get the impression from the case that the ANU were trying to do the right thing. But eventually, the university had to consider whether Professor Burns should be removed from his post due to what they then described as invalidity. They arranged for his case to be considered by the Commonwealth Medical Officer, and that officer described Professor Burns as a seriously ill man. The University Council decided to meet to consider whether to discontinue his employment, and the date for that meeting was delayed at Professor Burns's request. 2 days before the delayed meeting, his lawyers wrote to the university saying that they wanted the opportunity to provide still further information. They said that a further medical test was due to be conducted 11 days after the proposed council meeting. By this time, the university's patience had clearly run out. They chose to proceed with the meeting and they decided to end his employment. Professor Burns then challenged that decision. One of the university's defences was that this was not a decision of an administrative character made under an enactment. You see, the university itself was created by an enactment, the Australian National University Act 1946. But that act didn't specifically set out the working conditions of professors and academics hired by the university. What it did was to provide the university with the power to enter into employment contracts. They made an employment contract with Professor Burns. So Professor Burns says it was under an enactment because the power came from the ANU Act. The university, on the other hand, says this was a decision under his employment contract, not under the enactment. The court found for the university. Chief Justice Bowen and Justice Lockhart said, "In our opinion, the rights and duties of the parties to the contract of engagement were derived under the contract and not under the University Act. If either party had not fulfilled his or its obligations under the contract, then he or it would be susceptible to an action for damages for breach of contract." From this case, we learn that to be a reviewable decision, a decision must be made directly under the enactment.